page number 1953.
1953.
Page number. In the next page, my lord. Has given to the appellate authority in this regard regarding whether he is a resident of that particular so and so or not. So in the absence of that, para number 36, I can skip over and come to that point. In the present case, what has been happened is that an election petition had been filed against the election of the first respondent, and the only ground raised this election petition was that the inclusion of the name of so and so is. Then what the court has suggested is, you please obtain the certificate and produce it, but you cannot proceed on this basis as such. So,
Yes.
this is the first principle, my lords, which I intended to place. The second one, my lords, Rama Devi in her commentary on election petition. Good. Sir, my lords, in the small pages, my lords, page number 990, page number 3 in the bottom page number is there, my lords. It's arising out of the Rama Devi's.
Arising out of Rama.
Not extracted from the election laws, practice and procedure by Rama Devi and Mandretta. The Election Commission is normally following these guidelines. Kindly see 31. My lords, the 31, it relates to the declaration. If any person makes in connection with preparation of revision or corrections of an electoral roll, or the inclusion or exclusion of any entry in the form of an electoral roll, a statement of the declaration in writing, which is a false, and which he either knows or believes to be false, or does not believe to be true, he shall be punishable with imprisonment, so and so. Comment. The offense under section 31 is a non-cognizable for detailed discussion, so and so. Then, my lords, now section 125. 125 also has been discussed in the, by the same author on the next page. And page number 992, my lord, may kindly, bottom portion, page number 992, comments.
Comments.
My lord, got. The Election Commission has clarified to the returning officers that the nomination paper of a candidate shall not be rejected solely on the ground that the candidate has given any wrong information or suppressed any material information in his affidavit. If any such defect or the discrepancy is brought to the notice of the returning officer, he shall file a complaint before the competent magistrate under section 102 for having violated section so and so. Therefore, my lords, the Election Commission is also of the similar opinion. There is a one order passed by the Madras High Court, may not be.
Could is.
Beda, idu beda. Good. New place. Idare. ಅವಕಾಶವನ್ನು ನೋಡಿ ಇದೆ.
So ಅಷ್ಟೇ ಅಲ್ಲ ವೆಂಕಟೇಶ್ ನಿಮ್ದು ಇದೆಯಾ? Yes, heard result. Heard the Leonard Senior. Entry ಮಾಡಿದೆಯಲ್ಲ?
Lords,
ಇದೆ.
just one other aspect I just want. But the judgment which the Leonard Senior Counsel, that
Robert.
Robert's case
Hmm.
was pre-Lords 125 capital A. But 125 capital A, Lordships are aware, we are part of the large electoral reforms which were brought in, Lord, by which, Lords, the candidate was expected.
seen, I have not
No, I'm only bringing to Lords two sentences. Not only, Lord, 33 came to be amended, but 33A was inserted, by which candidate is expected to disclose to the electorate all the information which is necessary.
It's pursuant to judgment of the Supreme.
Honorable Supreme Court, Lordships are aware.
Yeah.
No, therefore, Lord, these are not matters, Lord, which now, Lords, in the post-electoral reforms have assumed importance. He must not only disclose where he's residing truthfully, he must also disclose
Yeah.
the kind of criminal cases which are pending against him,
You are
the assets and liabilities he has. This they say is part of
So
democratization.
all that will come come up for consideration once I decide maintainability.
No, I'm,
Whether the complaint at your hands was maintainable or not.
on that note, may I just,
That, this is what any other.
there are two other judgments accompanying that compilation. Of
Yes.
course, my lord, they were in different contexts. I must bring to lordship's notice.
Ah.
But observations by the learned single judge in the second petition, my lord, at paragraph 3, my lord, the running page is 10. But the judgment is of His Lordship Justice Narayan Swami, which commences from page 7.
Hmm.
Ali, they had
Division bench.
there is a reference to that. May I request lordships to kindly see page 13, not division bench judgment. This, though, not page 13 only, though this was in the context of a municipal election, lords, at page 15, page 15, paragraph 6, there is specific paragraph 6 of page 15.
This division bench.
Division bench, 125 capital.
Yes, Subro Kamal Mukhar.
How?
Yes.
But I am conscious of the
Remedy
fact,
of aggrieved person is to lodge
Yes.
a complaint
yes, under 120.
to invoking 125A.
No, my lord, in fact, my lord, I may put it across in this way, my lord. This information is meant for lords, advisedly for informing the people to make a choice. And if there is it is meant for them. And if there is a suppression to them, but according to my mind, my lords, it would be any of them who can come before the court and file. It's not the returning officer. It has got nothing to do with the returning officer. Apart from the fact that he makes a statement before a public servant, it can also be an offense under 171. But these kind of information are meant for general public. And if they find that any information which is given to them is false and conscious, so it would be open. And what the last argument, I'm sure what these maintainability questions have come up before your lordships on an earlier occasion. Unless they show a specific bar about maintainability. No, I'm only bringing to lordship's notice, but I am not
Since there
conscious
is no bar, it is maintainable.
because of the general principles. But of course, lordships notes in that extortion case, the other day
Yes, yes.
reported judgment, which where lordships say that in those circumstances, it was not maintainable. But here, my lord, as I pointed out,
That relying on section
yes,
39
the
of CR.
design of 125, what I may, at the cost of reputation, said design of 125 is meant for information to general public.
Well
Yes.
considered. Yes. Heard, so and so reserved. More, I think.
Mr. The other petition, we are not opposing. We are not party.
Allow madli anta.
I'm not party.
Party.
I'm not party, but on merit, so that it must not be taken.
Who is your opponent, Venkatesh? Rangaswamy. Yes. Next. Please. Both.
For the respondent, for the petition.
Defamation.
Please, my lord, for the.
Here, man. 9th January. List on January the 9th, 2025. For further hearing.
Further here,
For further hearing. Further hearing alai ide. In the same stage, yes.
entry.
Entry mode subsisting will continue till the next date of hearing.
Great.
39.
For petitioner yours,
Hmm.
kindly any short date may be given
Why?
for further. Senior is engaged in some another court, so
Some other court. Yes. Interim order ಇದೆಯಾ? Interim order ಇದೆಯಾ?
Yes.
Interim order ಇದೆಯಾ?
No, your lords.
No interim order. ಇದೆ. Check the file and see. You have an interim order or not? Not a precipitate, not extended. 9th can interim order subsisting, comma, if any, shall continue till the next date of hearing.
Much obliged.
Final disposal 40.
25 project ಮಿಕ್ಕಿದೆಲ್ಲ. 9th, all these appeals will hear on the 6th. 18th, ಒಂದು ನಿಮಿಷ ಮಾಡಿ. ಕೊಡಿ. call the final hearing case. 46th, okay. 9th
Ninth.
January, yes.
Finally, 41.
Yes, Balakrishnan, sir.
41, my lord. One is cheating case, another one is check case. Check case is admitted by this honorable court.
Where is the respondent? It will.
It's a cash for seat, cash for political MP, MLC seat.
We'll hear all this on 19th, all the appeals. 45. 41 ಅಲ್ಲ? ಕರ್ದ್ಬಿಡಿ madam.
42.
ಇಲ್ಲ 9th ಹಾಕಿ.
43.
9th same.
9.
19th, sorry, 19th. Entry model, these are all appeals there,
42.
same.
State.
State, dismiss ಮಾಡಿ. File ಇಲ್ಲ. File ಇಲ್ಲ. ದೊಡ್ಡದಾ? ಹಂಗಾರೆ 9th January.
44. 45.